Hello and welcome to our today's Coffee and Consulting. Don't get drowned. Workation needs regulation. I hope you all are fine and have started the week well. My name is Friederike Ruch and I'm the one who will now talk you or discuss with you that topic, which I'm sure in all of your companies, there are lots of questions about it as well. It's a hot topic as well. And the summer season is just in front of our door. Before we start, there are two things I would like to mention. One is on the right-hand side, you find a box where you can ask any kind of questions. Please do so. Please write them down while I'm going through with you the first couple of slides to provide you a bit of, from the regulation or the legal background, some input in it, as well as what the best practice currently is. So that's the time when you can now write down all your questions you may have already or may have once I started with the different topics. After the first presentation from my side, I will then answer all the questions we have received. In case you don't find the time to write them down, then you can just drop us an email and we will get back to you by email again. Also, you will find on the right-hand side the slides from this Coffee and Consulting. So in case you would like to download it, just download it. And the last bit is today's Coffee and Consulting will be recorded as usual, and then we will upload it on YouTube. So in case you would like to watch it again or listen to it again, there you have plenty of time. Then let's get started. Workation is something, I think the name is actually quite good. It's a combination of working and having vacation, and as easily or as likely someone would like to just say as an employer, you're a good employee, you can go and work from wherever you want. We are happy as long as we have the results and you work and the work is done, we are good with it. Unfortunately, that's not the only concern you need to have. The other concern is that there are a couple of legal restrictions, and then also the matter of how high or what is your risk appetite, so to speak. So whether you would like to have everything really in a wide way, so zero risk, then you definitely have to do a lot in regard to workation and to rule or regulate a lot of stuff. In case you think, okay, we try to kind of consider all the legal provisions, everything what there is, but we still also like to kind of have a more practical approach, then I think you can easily work with that. And in case you do have a high risk appetite, saying, oh, we don't care, I mean, we just basically say to our employees, they can work from wherever they want up to whatever number of days. We are not checking it. We are not doing anything at all. We are good with it. In case something happens, we will just take care of it then. This could also be a solution. So it's not that it's only one possible solution to that topic. So there is a variety. And if you check with your colleagues or with other companies, you will see that each company does it slightly different. And some of the bigger companies who have a bigger number of requests for those workation staff, might say we just we say our people can go maximum 90 days. We track that, but we don't check anything as long as they have the nationality from the country they're going to, or have a residence permit or something which allows them to work there. We are good with it. We don't deal with anything else. In case something happens or something comes up, we will look at it. And that is then really a very practical approach to it. Also seeing that we are aware of the risks, but in the end, if we see that if we would check each case and assess each case, which costs time and money, versus we just do, when something happens, we take care of it. So it's a kind of, everybody has to kind of find a balance with it. Now, due to I think basically COVID as well brought it up that working from home or teleworking is actually something which can, from an technical point of view, usually done quite easily. And now Workation is just so the kind of next step where you combine Workation and work. We've seen that usually people would like to spend then their vacation in the country they might be coming from, and just want to have an extended time, maybe also with their families there, if they are now here in Switzerland working as a foreigner, for example, and therefore there is usually not really a big issue in allowing it. However, there are also then requests like, I would like to work 4 weeks from the Maldives. Is that also fine? And there, usually you would need to say no, because at least as long as the employee has not the nationality of the Maldives. So it's a bit, not everything is possible, but in a certain area or a certain way, you can allow certain vacation stuff. What it needs definitely is a kind of a regulatory framework. So what you should do, or it would be good if you do that, is to kind of list down what you think, how you would like to allow people to go on vacation. What your company's approach is, what the process is, who will actually be the one also approving it or saying yes, someone can go, whether also, or how you also would like to track all the days the individuals go on vacation and work in that vacation, so that in the end there's also not a misuse of it. So you would need to put something down as a kind of a guideline or process, also to find the right work pattern, which is good for your own company, for the situations, for the employees you have. And it's also good to maybe check with your employees what their requests would look like. And there was I was listening at a conference to someone, and they were saying they had 30 days in their company, which would allow people to go on vacation. They make minimal checks on everything, and after a year after they had implemented it, they asked the employees, how do you like it? Is that really what you want? Is there anything you're not happy with? And the feedback which they received was, the 30 days are too little. We actually would like to have more. We would like to have something like up to 60 days. And then the HR went back and was checking on what actually were the requests like. So what has happened in the last year? How many days has everybody requested? And when they saw that the those 30 days, according to the employees, is not sufficient, in their opinion, it was then, okay, maybe everybody had actually used those 30 days to the last day. But the reality was that in average, the employees just asked for 7 to 8 days. So it was not even the 30 days. But in the mindset of the employees, it was too little, those 30 days. And when then the employees had been brought up or provided with the what effectively they have used, then they realized, okay, somehow what they thought is not sufficient, the reality was something else. So maybe that is also something which I thought is a good takeaway, to really track the days and then to see whether you are good with those 30 days, or even if you say you will start with 2 weeks, absolutely fine as well. We will look in a moment as well where those 30 days are coming from, and where they might be good to really be considered. There are a couple of legal aspects to look at, and one is the immigration aspect. I already mentioned that is something you really have to look at, and that is, the recommendation is you check on the nationality or on the permanent residence permit the individual has, and say you can work abroad in your vacation. However, you need to have the legal right to do that. And the legal right usually depends on the nationality or on the residence permit. So if we take an example like a French national working here in Switzerland, employed in Switzerland, and then would like to work, go to Greece on holiday and work from Greece, no problem at all. You can allow that, because based on his French citizenship, basically EU citizen as well, he is allowed to work in Greece without any problems. You may have to check, or would like to check, whether you have to do a posted worker notification, but in principle, he would be allowed to work there. Whereas if you have, for example, an American working with you in Switzerland, have a residence permit here in Switzerland, maybe even already is living in Switzerland for quite a while and has a C permit, if he would like to go to France to work there or to Greece for 30 days, then you would need to tell him, I'm sorry, that is not possible, because on the Swiss residence permit, as well as on his US nationality, he is not allowed automatically to work there. So there it's kind of where the restrictions are. Unless you would like to go and request a work permit. The problem is just for requesting work permits, usually you would need to have a sponsor for the work permit, and the sponsor is in principle a legal entity situated in that country. And as long as you don't have that, this option is then not any longer available for you. So the only thing is, what you could do is that posted worker notification, which we have in the EU, but unless that or otherwise, there is no other option. So basically, if you would like to draft something for your company and would draft a regulation for Workation, then the limitation on the countries is really in the end based on the nationality or the legal right to work and reside in another country. And that depends on each individual, and therefore you won't have a solution like for everybody really the same thing. However, if we remain with our example, where the French person was allowed to go to Greece on vacation, the American was not, the American would be able to go to America for 30 days and to work there, whereas the French national would not be able to do so, because there again, for him, there would be then the need to get a work permit. So immigration might be the one which limits the number of countries the most, I would say. The rest is a bit of more formality side. Like if you go to the Social Security part, in principle, someone could remain in, if we take Switzerland as the basis or kind of the residence country of the employee, then someone residing in Switzerland is already subject to Social Security just based on residency. And if he is now going to work abroad from his employer, even if it's on his own wish, he can continue to pay Social Security contributions in Switzerland while he works abroad. There are a couple of agreements in place, as well as a couple of Social Security treaties, which would also allow the continuation in Switzerland, that the employee can continue to pay Swiss Social Security contributions and then also get exempted from abroad. And you may know the Form A1, or have heard the Form A1 would be the applicable form if someone would work within the EU, or certificate of coverage if it's a treaty country only. So there are certain forms then the HR would need to fill out and get stamped. And then with that, basically, it's the confirmation that someone can remain in the Swiss system. Now, in case we don't have a treaty with the other country, and there are lots of countries where we don't have a treaty, then it gets a bit tricky. However, because if you limit the number of days to, let's say, 30 days, then usually in any country they don't start the Social Security liability already from day one. Usually there's a bit of 30 days, kind of a temporary period where they say if there is no employer in that country, there's no salary paid in that country, no cost borne in that country, which is all the case if we look at workations, then usually there is also no Social Security liability in that country. Now, that is kind of the usual concept from overall, but still that is something which needs to be then checked as well with the country the employee would like to go to. So from a Social Security perspective, you can have him remaining in the Swiss system. There, for those 30 days, there should be no problem at all. However, there might be a Social Security implication in the country he is working from, but that needs to be checked. But usually, as said, up to 30 days, usually nothing happens. Now, what we definitely will recommend is to get an international coverage. So the employee would have to go and see to get a health insurance coverage, which will cover him for that extended period he is actually in the other country, working and being there for leisure. And there is then always the discussion as well whether the travel insurance would be sufficient or really a health insurance coverage is required. In principle, and worst case scenario, then the travel insurance is not sufficient. It depends a bit on what happens. And we suggest that you definitely go, or the employee definitely go and gets the international health insurance coverage that is not that expensive. You can do that easily with the own health insurance you're enrolled with, and it's the better approach and the safer approach. So in case there is anything in the while you are on vacation, then you have the sufficient coverage and there will be nothing you need to worry. With just travel insurance, there might be the situation that they will not cover all the cost, and therefore at some point the employee might be in a situation which he doesn't want to be in, and he will have in the end to pay everything himself and has no insurance at all to actually claim those costs, and then might even go back to you as the employer and say, I had now maybe an operation which was not, I couldn't change. I mean, it could not be changed. It was just, I had an accident. There was the operation, and now, yeah, I have those costs. What shall I do? I have also worked for you, and then you as an employer, even you say it's your own thing, you had been on vacation, still you might be in a kind of, from a moral point of view, you say, okay, good, let's see what we can do. So it's better to actually be on the safe side and get that done. We had a couple of times the question whether that additional health insurance coverage for working abroad should be paid by the employer. From my perspective, that should not be a burden to the employer, and the employer should also not pay for it, because the initiation of working abroad is not initiated by the employer, it's initiated by the employee. And based on that, it should be also on his expense and not on the expense of the employer. But in the end, every company and every employer is completely free to do whatever they want. So there's not a right or wrong. It's just you make just the decision. And the other topic is about the income tax. Now, we do have with many more countries a double tax treaty, as we have social security treaties with. The double tax treaty should avoid that someone is being taxed on the same income in the other country as already paid taxes in the other country. There is the 183 days rule we would use for those workation situations, meaning that if someone is in principle less than 183 days residing in the other country and residing as well as working in the other country, then the employee should be exempted from the taxation in that country, but paying country in the main residence country. So based on that, if we take our example of the French individual who goes to Greece for 30 days, have their vacation as well, will work there. If in total he will be less than 183 days in Greece, he will be getting no salary increase. There will be no cost from the employer charged to a Greece Greek permanent establishment or legal entity. Then there is no taxation in Greece. The taxation on the income will remain in Switzerland. Now, there are also a couple of countries where we don't have any treaty with. Now, most likely that the situation that you will have an employee or the employee with a nationality where we don't have the treaty, double tax treaty with, might be towards zero. So having said that, you should not have those situations. However, also there, usually in almost or in most of the tax laws in the various countries, you will find that up to 30 days, usually someone is not subject to income tax. That will help those country or will help each country, because otherwise, if someone would get taxable already starting from day one, then we all would have, wherever we go, would have to file a tax return, or there should be some kind of formality to be fulfilled. Now, based on that, there should be no issue in regard to taxes. You might just have to be careful if someone had been living already for a certain period of time in that country, or had been before on assignment there and is now going back, then you might trigger those 183 days and then might have a tax consequence. But otherwise, there should be no problem. And there again, you will see those 30 days. So tax-wise, there should be no problem at all. Now, from a labor market, labor law perspective or contract perspective, there are two things to look at. If we take our French national who is employed in Switzerland, he has a Swiss contract. So all the provisions, everything is based on Swiss labor law. And if he now goes to Greece for those 30 days, then the only thing which we would have to look at is whether there are any mandatory provisions in Greece which are in contradiction to the ones in Switzerland. Meaning mainly we are looking at salary level. So in case the Greek salary level would be now higher than in Switzerland, then in principle you would have to actually pay the higher salary for that period the individual is working in Greece. Bank holidays, that is something you definitely have to look at and say, okay, at any bank holiday in whichever country you go to, you're not allowed to work. And that is something I think quite easily done. Workation entitlement, it depends a bit on the other country whether they have more entitlement, more vacation days as in Switzerland. Now we would look in our situation, look what is happening in Greece, how many vacation days do they have. In principle now, if we say Greece has 30 days, Switzerland, you maybe have only 20 days. So on a prorated basis, in principle, you would have to give the employee the additional holiday entitlement. The last bit is about the work hours per week. So what you definitely have to say is to the employee, in case in Greece there's the work hours per week is only 35, and in Switzerland in his contract is actually 42. Then you have to say, okay, you're only allowed to work 35 hours. Now you need to make a decision only what will happen with those 7 hours he is now working less. Will you reduce his salary accordingly so that it reflects also the 35 hours, or will you have the salary leaving as it is and just say, okay, we count 35 hours as you would have worked 42? Or, and that is a possibility in case you have, for example, an annual work time regulation, then you can say, okay, you just work those hours, whatever they are, the difference just before when you are in Switzerland or afterwards. So that it's in the end, there is no need for you to change the salary, as well as for the employee to he can easily take care of considering or making sure that he only works those number of hours. In practice, you will find lots of ways how to deal with it, and there again, there's the white way and white approach, complete white approach you can use. You can choose to kind of an pragmatic or practical, more practical approach, or you can say we don't care at all. Now, we don't care at all would definitely not be my recommendation. However, just doing it 100% white, you just need to know as well what the consequences would be and what the administration then behind would be. So I think if you go on a kind of a bit pragmatic way, that is absolutely fine. As long as you keep in mind, you know exactly what the situation is, what the provisions would be, and then you're basically good. On the right-hand side, we have found a couple of countries, a list about the countries with the most annual leave. And there you see, for example, if someone would go to Andorra, then you have from 20 days maybe in Switzerland up to 45 days. There might be a bit of a different situation to look at with it. So as a kind of sum up everything and a possible solution for Workation, we think it's something you will not get away with, and I think it's rather accepting the situation and saying, okay, we allow it for all our employees, maybe make some exceptions to it, like if someone has a terminated contract, then you will not allow it, or someone on an apprenticeship, you would not allow it. That is up to you, whatever you would like to do. But in principle, I think you're good if you just allow it to all the employees. In the end, not everybody will really request it. You will see that as well. So 30 days, I try to show you where they are coming from. I think that is really a maximum number of days you or someone could allow in a year. It's a nice benefit, I would say, and you can also market and promote it the way as a good employer, having that possibility that someone actually can work from another country for you. The limitation on the destination countries, that is something you should really look at. And if you define that really by nationality of the employee or the right to or entitlement to work in another country, then you are on a very good track. Write down the guideline. That doesn't need to be a booklet of 40 pages or something. I'm just thinking about the usual guidelines, how you would like to go about it, what you will allow, how the formalities are, and then everybody knows exactly what you're offering, the kind of responsibilities as well from the employer, from the superior of the employee, from the employee as well, and then it should be you should have something which is really workable and good. Define the formalities and define who is doing what. Take over maybe a couple of the formalities yourself, because in the end, if you kind of outsource it to the employee and say he should take care of it, if he doesn't do it, it in the end falls back to you. So in regard to that, I rather recommend you to actually take care of it instead of just let it go. The international health insurance or the additional health insurance coverage, that is really something we would recommend for the employee, because you never know what happened, and We saw during COVID as well that you can, from day 1 to day 2, you can be stuck in one country. And for that, it is very good if you have then also the necessary coverage. And make an awareness as well of the risk towards the superiors, as well as towards the employees as well, so that they all know what they have to look at and what they do. Now, we were asked, or we usually are asked whether you would now add kind of an addendum to the employment contract for this, or whether just writing an email would be sufficient. I think that is really depending on the communication style of the company. I think an addendum to the contract might be a bit too overwhelming and too much for it, but it's definitely the best way. And if you go the white way, then that would be definitely the solution. Whereas just putting down everything in an email, if usually you communicate only by email with the employees, and that is kind of today also in most of the companies a standard, then that should be not a problem at all. What we would recommend is just really to put something in writing and list down the different matters so that the employee is aware of it, as well as you have something you can show that you have informed the employee as well. And on the right-hand side, we found a list about the most desired and top-ranked destinations in Europe where apparently people go to. So Switzerland is actually on place 4. So we are quite good apparently also as a desired country to work in. Maybe more during the winter season as the summer season, but I don't know. I don't know where the numbers are coming from. So that should give you, I think, a good overview about the Workation, and so that you don't get drowned with everything. Now, I've seen that we have received a couple of questions already. So let me see. Okay. The first question is, do you have any experience on inbound workation within Switzerland of an EU national, for example, a German national wanting to do workation in Switzerland? Is that possible without any to do, or would the notification requirement be in place? So for a German national coming to Switzerland, you would have to do the notification requirements, or the Meldeverfahren. Because the thing is, he is not just based on his nationality, he would be allowed to work for a Swiss employer without a problem, but not for a foreign employer. And therefore, you would need to do the Meldeverfahren, or the notification. You also would have to look at the salary level, because the German salary level is less than the Swiss salary level, so there might be even then that you would have to actually add something to his salary. In regard to Social Security, there's no problem. You just will request the A1 from the German Social Security Authority, which will allow him to be exempted from the Swiss Social Security. Tax-wise, there is the 180 days rule which comes into place. So if he's just coming to work here for 30 days or whatever, then there's no problem in regard to taxation. And in regard to labor law, it's Workation-wise, most likely the German entitlements are higher than the Swiss ones. Number of work hours are usually less or similar to the one in Switzerland, so there you should also have not an issue. Therefore, basically, it's the notification from an immigration perspective, the salary level you would have to look at, as well as you would need to get the A1, and then you're basically good, as well as the employee should get an international health insurance coverage for Switzerland. I hope that answers your question. Then the next one is in regards to labor law. Why should the mandatory provisions of the destination be taken into consideration? I, as the employer, did not send the employee and expect him to work according to Swiss working schedule. That is absolutely correct. The employer itself did not make the request. The employee did it. However, the benefit out of whatever he is working is for the Swiss company or for the employer. And because he is working not for himself, but for his employer, therefore also the the mandatory provisions of the labor law of the country in which he is working have to be considered. So there is no, even if the employee has not requested it. And the same thing is, as I said before, in regard to the notification requirement, usually it is the notification requirement is for assigning someone to work in the other country. We just use that as the kind of vehicle in order to get it legalized. And the immigration, as well as also from a social security perspective, requesting the A1 is also usually for someone you assign to work in another country. It's not just if the employee comes up and says, I would like to work in the other country, and then you would do that. So we just use that part in order to get it kind of regulated. I hope that answers both of your questions. There are a couple of more questions which we will then, due to time, answer separately by email. I hope you enjoyed it and got the one or the other input for you and for your company and for dealing with Workation as well. I just would like to use the last second to let you know what you can next expect from us. There is on the 29th of August our webinar about the challenges on the cross-border employment side between Switzerland and Germany, as well as on the 3rd of October, where we again will talk about remote work and workation in much more detail. So in case you have until then maybe already started a guideline or started your process and everything and would like to check the next steps about it or have more questions, need more insight on it, then that would be might be a very good seminar for you to get everything then rounded up. With this, I actually will close today's coffee consulting. I hope you, as said, you enjoyed it. I hope you can take away the one or the other thing, and I wish you a wonderful week, a wonderful summer, and hopefully to see you soon at one of our next events. Thank you for your attention.